I find that no matter how often and how frequently I remind the client just how expensive this can all get and how quickly that can happen, and then it still somehow comes as a shock down the road when things have kind of gone a little bit off the rails. What do you think about that?
One thing that I would do, whether the department head wanted to do it or not, I would schedule a monthly hearing. For instance, in particular with the assessor. And I'd say, I don't give a damn if all we're doing is looking at each other. We're going to get on top of whatever litigation issues come up. You can't acknowledge where the other side is coming from.
So welcome back, everybody, to Unlocking the Law with me, Brandon Grysko. I'm your host. Podcast where we tell authentic stories about the law, break down barriers you may have to working with attorneys, and explore topics of interest to businesses and communities. We try to do this in a modest way with a little bit of humor mixed in here and there. Joining me today is the great Jack Gilbreath. I've known Jack for a long time, and you'll forgive me if I botch this, but I'm mostly going off memory. Jack is an administrative hearing officer with the City of Ypsilanti and the Administrative Hearings Bureau. Served many years as an administrative law judge, I think assigned to the tax tribunal. And then prior to that was a practicing attorney, perhaps best known for his work with the City of Ypsilanti. And I know Jack actually, though, as an adjunct professor at Cooley Law School, where I went, and where Jack taught me pretrial skills, and where I know he also has a state and local government course that is very popular. So, Jack, welcome to the podcast.
Thank you very much. Look forward to talking with you.
So, tell us a little bit, tell the audience just a little bit about yourself. I know I kind of gave some high-level details there, but just a little bit about the trajectory of your practice, maybe.
I graduated from law school in 1982 and passed the bar there. For the first year, when I graduated, law schools did not offer practical courses for the most part. And so when I walked out the door, I just had to practice. Ultimately, I ended up in a firm, and I don't know if anybody out there would remember, it was called Hyatt Legal Services. And it was a nationwide general practice law firm. And it was, and I happened to be at an office called at the corner of Telegraph Road and Michigan Avenue. It was the busiest of this, probably the 10 offices in Michigan. And the one thing I gleaned from that is I was in court all the time. All the time. I mean, all sorts of cases, mostly domestic, some district court stuff, and whatever. That I got my start there, and ultimately I have worked through time with the various insurance defense firms. And one thing I learned about in doing that, there was tremendous concern about how much litigation costs. I remember somebody telling me that any adjuster put a value on a case, and you were supposed to try to fall within the parameters as you developed the litigation. And so I became aware, both working at Hyatt Legal Services and this insurance defense stuff, of what money meant in terms of its involvement in the legal process. When I was in law school, the most interesting courses I ever took were, by the way, I graduated from Detroit College of Law, which is now Michigan State, but I haven't changed my diploma. They send me these notices, and I get all the alumni stuff. But I have not set foot on that campus. But at any rate, I took a course called Arlington Heights versus the NAACP, which was a constitutional law case, substantive due process, I think. But the most important thing is showed how the law could affect communities. And I thought someday I'd like to be involved in that process. And ultimately, I got there when I was hired by a firm in Ypsilanti, and I became a city attorney. And the beauty of that for me was I was subject on any given day to a different legal challenge. In the meantime, prior to that time, I got hired by Cooley Law School to teach a course called pretrial practice. But when I was working with the city in this law firm, I had an occasion where I got hired, but we did principally municipal work, but I'd pick up the odd case, and I got a guy coming in and he wanted to do a challenge his, or try to change his child support obligation and amend the divorce judgment and all the rest. A very nice guy. And the law firm that I worked at, the principal there was just absolutely meticulous beyond any way of describing it in terms of communicating the client attorney relationship, to the extent that when they left one of our sessions, they had a pamphlet that they would take with them that would include all the documentation, client retention files, the fee agreements, everything. So there was no question that everything was covered in, so that you could have a binding, productive client-attorney relationship. And in there, there would be a retainer agreement. And I remember, and I was the worst person at evaluating those things, and this guy signed up with me. And after about 3 or 4 trips to court, which I never accounted for, my office manager, we were going to court, hopefully it was going to be the last time, she gave me an invoice and said, give this to the guy, he owes us his money. And so I'm right in front of Washtenaw Circuit Court, and I hand it to the guy, and he said, very good-naturedly, he said, I never thought it was going to cost this much. And even though I walked into court, we got it resolved, that gnawed at me. Because where in that process of communication did I miss something? And so I went back to that office and I said, okay, what is this all about? And so the paradigm shows a horizontal line that goes from complaint to hearing. Now, when I sat down the first time, all I did was draw a line. I put complaint and I put hearing, because everybody wants the comment, it wants to go have a hearing or whatever. And then, as the paradigm shows, I interviewed the guy, and I had to explain to him how much this was going to cost. And so, without any of the embellishment on the most recent iteration of the paradigm, there were just 2 lines. There was this horizontal line, and then there was this line going up. And what that represented was a number of factors. And I concluded that when I interviewed with the guy, they had all the control in the world over what was going to happen. They could just turn around and walk out the door if they wanted to.
That's right.
And that is ADR, actually, in my definition, alternate dispute resolution. And the other thing, we had an initial charge of $50. Mm-hmm. So they paid $50. They got the info, blah, blah, blah. They're on their way. But the reality... So
just let me interrupt just real quick, because I find that, and maybe it is a communication failure on the part of attorneys, but I find that no matter how often and how frequently I remind the client just how expensive this can all get and how quickly that can happen, depending on what you have going on. I don't know if they don't believe that that's really going to be the case, but there's been times certainly where I feel like I've communicated that, and then it still somehow comes as a shock down the road when things have kind of gone a little bit off the rails. What do you think about that?
Oh, I think it's one, biographical information. I'm a clinical social worker, and that the skill you develop there is listening and communicating and whatever. And I use that a lot. The thing about that you're talking about, and when I tell my students, is how many of these clients are really thrilled to be there. They're going in to see, it's like going to a doctor.
None.
And it's not because it's a bad profession. It's because of the anxiety associated with that issue. Here this guy comes to me and he wants to get his divorce judgment amended. He's got no relationship with how the law works. And now he's listening to what's going on, but he's not hearing anything. And part of that is because of the anxiety of being in there in the first place. And that's what I found. You know, the planning commissioner, when I talk to them, they're suspicious of my challenge. Whatever, as much as I wanted to make sure that I was on his side, et cetera, et cetera, et cetera, there's apprehensions about that relationship and where that's going to lead, the impact it has on their lives. And so that, I think, mutes what they're hearing. And that was what's so critical at the firm that I was at, because we had graphic documentation. I mean, everything.
Well, and that's another interesting thing, because you can oftentimes, communicate information in various formats, in writing, verbally, etc. Graphically, I think is probably a great idea. We've all had those experiences, though, right? Where you hand the client a stack of documents, and how much of it are they going to read? It's up in the air. So that's all pretty interesting, and I think very important. So just by way of introducing the topic before I let Jack continue going with that, what the paradigm I think comes out of is questions that I get asked to answer almost constantly. How much is this going to cost me? One of them. Why do so many cases settle? These are questions that people want to understand, especially in the context of local government. I find a lot of residents that are interested in and try to be involved in showing up at public meetings, and they want to comment on what's going on. They hear about, the council is voting on settling this case or that case. And I think there may even be a perception that the government has done something wrong, which as Jack, I think, will explain to us, is not necessarily the case. I also have people that'll ask, do I have a case? Can I sue? Those sorts of things. And I think some of the factors that Jack's talking about directly bear on those questions. There's this general idea that, I have a contract. The contract says they owe me A, B, C, so this should be simple.
Yes.
They have not done A, B, C. So if I hire you and you walk into court with a copy of the contract and my statement that they haven't lived up to their end of the bargain, then that should be pretty simple for a judge to look at that, agree with us, and rule in our favor on. And that is also something that I think can set expectations for the client that are, as we're going to find out, unreasonable. And then as it plays into the economic factors, this kind of idea of I have to pay my own attorney fees all throughout this whole process, and it's going to cost me how much? So any of those questions resonate with you as you're thinking about, maybe reflecting on how you developed Gilbreath's paradigm?
There's no question about it. The deal is, in the paradigm, it talks about a complaint. There's a starting point. And anytime you engage a client, I think there's the expectation there's going to be a resolution, and that's going to be the opportunity for me to be heard, which is a hearing. And so there's all that apprehension associated with what that process is about and what their involvement is going to be. And that's why I go back to the example I may have talked about where the city planner is saying, I didn't know I was going to have to be deposed. They're totally oblivious to the process, and they don't understand it.
So for some of my viewers, just real quick, they may not necessarily be familiar with that. What is a deposition?
A deposition is a sworn statement that a person has to make. So it's under oath. It's part of what I would teach in my pretrial courses, the discovery process. So in other words, a case starts with some sort of petition, complaint, blah, blah, blah. And depending on where this case is posited, there might be this activity called discovery, and the idea of discovery is to try to enable each side to figure out where the other side is coming from. Now, the thing when you were just talking a minute ago, a lot of people this is my position. They don't acknowledge that there could plausibly be an opposition to this. I've been a judge, I don't know, maybe about 15 years or so. And when I sit up there, I look at these people that are litigating this case, and I know that at some point in time, they paid short shrift to the other side. And by the time they get to me, hopefully they have learned something about what the other side is about. But that's one of the things that leads to a misconception of what this is all about, because the person comes in, they want to get some resolution to an issue. They're not going to acknowledge the veracity of the other side. I hear that all the time. And especially when back in the days of higher legal services in a domestic relations context, where they would not acknowledge that there could be another position than their own. But that's, my experience tells me that thinking exists in many types of litigation. Mm-hmm. You can't acknowledge where the other side is coming from.
So I think maybe that's where we probably need to do a better job as attorneys of explaining to the client. And as you talk about your paradigm, so everybody, Jack's talking about a paradigm that begins on the one side with the beginning of a case, right? Maybe it starts with the interview, and then from there proceeds to the complaint. You've got some motion practice that may occur. Then you've got forms of discovery, which may be written responses to questions, depositions, which is what Jack was just explaining. And then eventually you're going to get to a hearing, right? It may be a trial. It may be a preliminary hearing of some type or a summary disposition motion. And so the question is, as the attorney, as you're learning additional information, right, once you get to the point of the hearing, the control, like Jack is saying, is now out of your hands, because now you've got a decision maker that's going to make the ruling based on whatever factors he or she finds to be important and persuasive. But as the attorney, before you got to that phase, have you advised your client of, hey, you know, we've got these facts, right, that work really well in our favor. Maybe there's a contract and it's been breached. And so that works really well in our favor. But as legal counsel, as counselor, have you counseled the client that, you know what, but there's these other facts out there that have come out in discovery that we've heard them talk about in their depositions. And if a judge puts some credibility to those things, that doesn't play well for us.
Exactly.
And that then, and it's not, and I've been accused by clients before of, well, you're on their side or you're not on my side. And so you have to have some sensitivity, I think, to how is this going to play and how do I package this up for the client to understand where I'm coming from on this. It's not that I'm being too nice, or it's not that I'm trying to advocate for the other side, but it's that if I'm not doing my job, if I don't show you the other side of things so that you as the client can make an informed decision about when or if is the right time to settle. Maybe.
The litigation, this whole process is complicated because it's got all those variables baked in it. You might be up against an attorney that will not back down, will just fight you tooth and nail in spite of the fact that they're just coming infinitesimally close to the precipice of committing malpractice. And I've had that happen. And how do you explain that to the client? Because what that ultimately ends up happening, and you sort of alluded to it, is the cost then is going to be affected because of that attitude of this other attorney. So in this whole process, it has to be explained, I think, that not only do you have to explain in infinite detail as best you possibly can, acknowledging the fact that the client may not receive and understand everything until later, but you also have to develop a relationship with the other side and try to work with that. And I always thought when I was engaged in this sort of process, you know, how do I do that and how do I explain that cost to my client? Because you hit the nail on the head. They think they're right. They shouldn't bear that cost, but it's part of the litigation. It's all part of that litigation. And so the cost as the paradigm shows, as it goes up and up and up, you're losing, you have to communicate to the client about what is transpiring here. As the discovery is basically an effort to narrow the issues. As those issues narrow, then you're realizing that there are maybe some litigated issues, but it's going to cost you at the end of the day with the cost of doing this discovery and everything else, and the cost of the hearing. And in my experience, the big deal is, at the end of the day, you don't have any control over it. As my Civ Pro instructor told me in the first year law school, it depends on the judge's itchy tweed. I wear those itchy tweeds. And I know the difference. Yeah. I know the difference from being a litigant wondering what's going on there and being that person making a decision. It's a hell of a lot easier in some regards to make that decision than to have to try to decipher and go through and understand and do all this communication.
So as somebody who's, as all judges obviously have been on both sides of this, because you've been an attorney usually for some period of time and then you become a judge. What do you wish that the advocates understood better about what it's like to be in the itchy tweed role?
The first word that comes to my mind is fairness. And the reason I mention that is because, typically speaking, each side has some merit.
Right. It's usually pretty uncommon that you've got an open and shut case.
Some of my cases it's pretty clear, and it's easy to make that decision. But I don't know how. When I was at the Michigan Tax Tribunal, I had one case called the Palace of Auburn Hills versus the City of Auburn Hills. That was a 3-week trial. And
that's a long time for anybody that is watching that is maybe a layperson. That's a pretty long trial.
And it was all experts. And it was, so that meant, and so you're thinking about how in God's name can you just flat out make a verdict for one side as opposed to another. I mean, there's merit on both sides. Fortunately, I had a law clerk that helped me with it, but we kick it. But that is the thing that always strikes me. Even with my cases now, they're not nearly as complex and all that. I want a resolution. There's, in the back of my mind anyway, I can put the hammer down, but there's always this idea that, what kind of hammer do I want to bring down? Do I want to bring down a hammer that's going to allow people to now change their behavior willingly? They got whacked. Mm-hmm. It's not like they're people that are going to keep doing this. You're hoping that they're going to get, and so that goes into my thinking to some extent. And then there's just people that, okay, the easiest solution to this, just make a damn decision. Mm-hmm. In either case, I'm making a decision. It's going to be fruitful. I think, I hope, and I don't get grieved.
So I wanted to follow up on, I'm going to ask you 2 questions. One is, how have you seen the paradigm at work in private practice where it's helped you? And then another time of whether or not maybe you've seen the paradigm at work from the bench. So how has the paradigm helped you with clients back when you were in private practice?
When I finally wrote those 2 lines. Now,
on one side being time, and on the other axis being cost, I think.
Yeah. The horizontal line is the litigation. That's time. And then it's cost. And then it's control, no control. And by the way, whenever I met a client, after I drew that, I'd always draw it for him. Somebody comes in, I have maybe a family dispute of some sort or another, and I would say, okay, I want you to look at this line, and this is what's, I'm going to explain what's here. I didn't have any of the embellishments whatsoever. But I just say, I want to get the concept, because I felt that having it graphic mitigated against people just missing the onslaught of explanation without any concrete visual aid. I mean, I could put on, I suppose I could have given them a book and whatever else, but they're not going to use that. So that's how it worked. And the classic example, and what happened is I then filled in some of this stuff and negotiation, and there were two students in one of the first pretrial classes I took where I explained the paradigm, and they did a law review article at Cooley about the paradigm.
Okay.
And they added some stuff. And so, for instance, timeline of a case from interview to hearing, it says negotiation and mediation is possible throughout the process. I mean, you can, I tell them, you know, let's say somebody hasn't sent you some interrogatories, for instance, on the other side, and you got to call them. And I don't know how many times this has happened to people, but invariably this conversation would go as, how you doing? I need those interrogatories. By the way, have you talked to your client? That's a negotiation. You're beginning some conversation with the other side, and if they're amenable, now you're because you're learning stuff about the other case and where there's going to be differences and where there's going to be problems and all the rest of it, and that sort of greases the pathway. And for me, I saw that happening all the time. You're always communicating with people.
Do you feel that explaining the paradigm? So, for example, when you were doing work with Ypsilanti, you were more institutionalized there rather than it being like a one-off client. Did you find that over time of working with the same people and sort of explaining the paradigm, did it have an effect, like a change in behavior on how they looked at decision making, or did you see anything like that?
You mean from my clients?
Yeah.
Oh yeah. Oh, yeah, and that's why the city manager said, show this to everybody. I mean, and when, let's say in a 6-month period of time, I would have had I remember we had a uniform, you know, the Cintas was, and it was an arbitration. So you're going to do an arbitration there. And then we had this huge streetscape that was being done where they dug up all this stuff and blah, blah, blah. And I remember one of the contractors left, just walked off the job. Well, now you got bonding issues. And so what you had to do is communicate what to do with that bond, how far you want to push it. I mean, it goes on and on and on. And then, and that's frankly why I like the work, because it was so varied and I was exposed and learned about various things. And so with the city and in a context like that, you were always in a situation of having to learn and having to explain what is going to happen when they take a position and are asking you what we should do. Then the paradigm comes out. Because this is what's going to happen. You got a number of choices. You can sit down and you can resolve it. You know, I've done that before any litigation, sit down and negotiate with people, or you might be in for the long haul, depending on how. So the paradigm explains it all, and it's graphic.
I like to think of negotiation and mediation as options that, because we've talked about that as time goes on, you typically see your costs go up and your amount of control that you have over the outcome going down.
Right.
Well, if you're able to get into a negotiation or a mediation situation, you're now reintroducing. You may still have some sunk costs, but you're reintroducing some measure of control into the outcome now that you didn't have before, and you're reintroducing the ability to control costs, not necessarily so much the sunk costs, but future costs.
Exactly.
Back into the equation. Now you've been able to claw some of that back through. What you've said is ADR, and what for my listeners may know is alternative dispute resolution.
Yeah, that's exactly it. I mean, and you know, I think in some instances, clients feel empowered. They're working, and you know, the other thing is, over time, and I from my own piece, I'd attribute it to the paradigm. The client respects you more because you've explained it in such a way where the fear now, there's still a fear associated with the litigation, but it's being minimized. And you developed a relationship with them as people. And what is on a number of levels, that's super important because you can then explain a negotiation and resolve. But the other thing, from their point of view, you have become their attorney. You know what that means? That's possessory. And what that means, they will refer you to other people. They will refer you to their friends. That's how you generate business.
Yeah, it's like it's moving from a one-off, a transaction, to more of a trusted advisor or a general counselor type of role.
And that's what you want.
Yeah.
Not so much for the money, not so much, but that's being a counselor in that respect is great because you can help minimize the cost of things. They can do some things on their own. And
you start to feel more like a business partner versus an expense on the sheet.
And I don't know how it fits into your practice and what you're doing, but I've known people that I'm a counselor. That's how they refer to me in a social situation.
Right.
And why is that? Because I've counseled them, and it's been effective, apparently. And I am their attorney. Yeah, that's huge.
And it's hard to quantify, I think. But we think about it in terms of we're problem solvers.
Exactly.
Right, but we're trying to do it strategically, and so sometimes you look at the paradigm, and you think to yourself, okay, well, maybe we've got some merit here. The other side maybe has some merit too, but the likelihood, I think, probably to the 99% mark, right, is that you're going to settle at some point. And so sometimes litigation is a means of forcing that conversation and getting into a settlement discussion that you wouldn't necessarily have had before. Other times, I've had these cases come up very recently where you go into it, it becomes readily apparent that the likelihood of any meaningful settlement is almost nil. And we just recently got done with the trial where that was the case, and then we won. But now, what your paradigm doesn't show is that after the hearing, even when you win, if you win a judgment, now you're spending money maybe collecting on that judgment, and there's further time going on and further control that you don't have, right? And more expense going into collecting on that judgment. And then other times, even if it's not a big money case, you may then have appeals, especially if you're dealing with insurance companies or banks or local governments that have institutional money, right? And now they're appealing, and you're waiting even longer and spending even more time potentially on achieving whatever the result is. And in the meanwhile, your control is still evaporating.
I don't know. Was I the only professor at your class? Was Colleen?
No, it was just you. There was somebody, Christine was helping out. I don't know what I think she may have been a teacher's assistant.
Yeah. But I used to teach this with a woman who was an Oakland County Circuit Court judge, Colleen O'Brien, and she's now at this Court of Appeals.
Oh, yeah.
And she told me one time, because she saw the paradigm. Great. We had a wonderful relationship, and she told me that in her, I can't even imagine what her docket was like, or any circuit court judge. And she said, at best, maybe 2% went to a hearing. At best. So that explains the significance of this whole pretrial process. The other thing in that case that I told you about with the Auburn Hills, now that's an administrative trial. And I always took the position I couldn't distinguish between a trial that was in a quote-unquote court of law or an administrative court of law.
Same type of stuff going on.
The same type of stuff, and there was always discovery. Now, you ask from a point of view of a judge, when I'm looking at something, I'm looking at how much discovery did they do, in a sense, and did they learn anything? And you know, that the obvious control that I would have over that is adjourning something so they could sit down and talk about it. And adjourn. I know that litigants get really angry at that.
Sometimes we do.
But I'm not going to make a decision if I don't have the required information to be able to make an informed decision. And so that's, in my own mind, that's, as you ask that question, that sort of explains how that falls into that activity that I was doing.
And maybe, I don't know if it, in the ALJ sense, did you ever have settlement conferences?
Oh, yeah.
And,
Oh, yeah.
and does
Oh,
this
yeah.
play into that at all?
Oh, yeah.
Okay.
Oh, yeah. That happens all the time. And in many of my cases at the Michigan Tax Tribunal, I was on the tribunal and then I became an ALJ for them. But what I would do is I rather than doing a hearing, I would just do a motion. And the tribunal rules, which are specific to them, say that if a rule in these rules does not, you can always revert to the Michigan General Court rules to embellish upon what they have. And so I would do a C10 motion, C9 or C8 motion, or one of those in order to resolve the case. I do that all the time, because why spend hours in a courtroom if they can? And part of that was based upon just making some admissions, jurisdictional, for instance. And then it comes down to interpretation of law or whatever the case might be, and that's one thing I would do in that context.
Are there any cases you can talk about where the paradigm has been particularly helpful? Maybe that you haven't mentioned already. I don't know if it's ever come up in a context where you felt like it really made a difference with the client's decision making.
Well, to be honest, once I made that presentation to the city, all of them became easier.
Yeah.
Seriously, because all of a sudden they get parked off into their own little echo chamber and wouldn't be listening to anybody. And just once that was put in front of them, the whole tenor of the city attorney department relationship changed. One thing that I would do is whether the department head wanted to do it or not, I would schedule a monthly hearing. For instance, in particular with the assessor. And I'd say, I don't give a damn if all we're doing is looking at each other. We're going to get on top of whatever litigation issues come up. And she knew. And the reason she knew is because she knew what was going on in the process. And that's the paradigm.
Yeah.
So that's the specific, I can't think of a better example. And ultimately, I got to the position where I wasn't doing the litigation so much as I was judge. And so I got away from it without sounding whatever. I mean, this is a great way of viewing this whole process that we're engaged in. And it's,
I think it takes account of some of the economic factors that drive the decision making of the litigants, and I think the other thing I like about it is that I don't think we should kid ourselves into thinking that these are all rational decisions based just on the dollars and cents. It also plays into some of the emotions that go into how the client is going to look at making a decision in these cases, and I suppose some of that probably comes from your social work background.
absolutely. But you're absolutely correct. Lawyering is from a client's perspective, and I said it before, name a client that wants to be in a lawyer's office. They don't necessarily want to be there, but they have to be there. And to the extent that you can minimize that anxiety, I alluded to it earlier, that's when you develop a relationship that can...
And, folks, just think about it. You might be a doctor, and you might be an excellent technician. You might be great at diagnosing and treating disease or doing surgery or whatever the case may be. But if you can't deliver the news of the diagnosis or the treatment or the prospects of success, if you can't deliver that information effectively, then some of those skills that you have is going to go out the window. And so I think if I can translate what Jack is saying is that in a lot of ways it's the same in the legal profession. We can be really good researchers and writers and procedural experts on the court rules and things like this. But if we're not able to effectively communicate that information to the clients in a way that actually helps them be in the driver's seat in making those decisions, then we're not doing our jobs as good as we could be.
I couldn't agree with you more, and I talk to people about that. Doctors have a great wealth of knowledge, but if they don't have that bedside manner, good luck.
Right. So
you're going to have problems.
Conference room side manner.
That's exactly.
Courtroom side manner.
But I will tell you this, between the two, how often are you going to be able to sit down with your client, whether it's as an attorney, I honestly think you're probably going to spend a hell of a lot more time with that interaction, because I think that's part of what being a lawyer is about, of the empathy, of trying to understand all the issues and all the various things. And it's not that the doctor doesn't have the same thing, but it seems to me that under certain circumstances, they're on more of a whatever.
Yeah. It's a different profession, different skill set, but the commonality, I think, is you've got a technical skill, and if you're trying to be effective in your client representation or in your patient care, in the case of a doctor, you've got to have the soft skills at an appropriate time.
Exactly.
To have that discussion.
So let me turn the table.
Sure.
How has the paradigm helped you?
The paradigm has helped me because I think, actually, believe it or not, I use some of the words that we've said here today in terms of the case starting, and as time goes on, you've got a loss of control and an increase in cost. I've used almost those exact words with many clients that are contemplating litigation, and at times I think they've decided to proceed anyways. But at other times, I think they've decided, you know what, maybe whatever that dispute is isn't worth it. One example could be, a client who has a case for maybe 20 or 30,000 or something like that against somebody that didn't pay. Well, how long is it going to take you to collect on that? You and I know that a case can easily, from the time that you file it to the time that you have some resolution, could easily be 2 years, sometimes 3 years. But I would be very surprised if it was less than a year, a lot of times. So you've got the passage of time. And in that time frame, you've got whatever investment you're making in attorney fees, but you've also got the emotional investment that comes from being in dispute with somebody. And even if it's a business case, there's still somebody's time and attention has to be focused on this, and it's taking them away from focusing on other things. And nowadays, maybe back, Jack, when you were actively practicing privately, I know that inflation wasn't where it's at today and different things like that. But I mean, 20, 30 grand in attorney fees, you can blow through very quickly in litigation. So just being able to have a candid discussion with the client about what a reasonable timeline looks like for a court case.
That's it.
What the costs are going to be and at which points you're going to begin to incur those costs and see them tick up. The fact that we don't have control. For example, we had a case where we anticipated some level of cost associated with seeking a temporary restraining order. Maybe that was going to go to a hearing pretty early on. And what is that going to look like? Well, we realized all those costs, but then there was an attempt also to remove that case to the federal court. And so now we're doing motion practice and briefing to try and get that remanded back to state court. And that's something that we really hadn't even anticipated. I mean, all those things remain a possibility, but you can't control the timing of when your opponent is going to pull the trigger on something like that. And you can't control the timing of, say, when a motion for summary disposition is going to be filed, and then the level of effort that it's going to take with that, or how much discovery is going to get thrown your way, how many depositions they want to take. All these different sorts of things tend to be reactive rather than proactive in some sense. And so as attorneys, we're responding to those things. We have to respond to those things in order to be providing good ethical representation to the client. And so being able to have the paradigm and go through it with them on the front end, at least verbally, if not graphically, has been helpful for some people deciding, hey, you know what? I think I'm going to take this approach versus that approach, or whatever we do, we're going to have an off-ramp in here somewhere. And so I think being able to provide that for the client's been very helpful.
You know, it's interesting. It's great to hear what you had to say. Is as you're describing it, you're talking about these things called motions and all these various legal terms. And when I teach my state and local law course, and we're talking about jurisdictional issues, I'm often think about the idea you're talking to a client and you're saying, I'm not sure they have standing. Now, a client that doesn't know the law is going to think, what do you mean, standing? Well, that's a very specific, and so much of what we have to deal with in terms of the actual practice involves terms that you really have to be able to explain it. So standing is not standing up. Because who's going to know right off the get-go what standing is?
The reason I think that in particular is such a good example is because, folks, you could spend a year or 2 years fighting about standing. Do you have, as the plaintiff or petitioner, do you have standing to even be in court? And you can spend a number of years fighting about that, and you could lose it and then win it at the Court of Appeals and then lose it again at the Supreme Court or vice versa. So you can spend years fighting about all those issues, and by the time you actually get back into the trial court to proceed with your case, it's now been several years of just fighting about that one issue. And you can't necessarily predict that going into the case, but as far as the paradigm is concerned, you've gone all the way up here on your cost, right? You know, and so that's a driving force in decision making and whether or not to settle a case.
Yeah, and you know, I alluded to motion for summary disposition. I mean, I think if you took the man on the street and asked him, what do you think that means? Summary disposition. What's my disposition? You know, there's things you have to explain, the legal terms, and that's a skill. Right. And that's what you have to do, because that fits right in to what the paradigm is all about. There's, you know, it's discovery isn't going to Olduvai Gorge and digging up a skull of man. Discovery is a legal term. ADR is a legal term. Pretrial is a legal term. And each one of these things you have to be able to have the trust in the client to get that information, as well as, and most importantly, to explain it.
That's right, because ultimately the paradigm is something that attorneys will come to understand intuitively at some level.
Right.
But it's a tool. It's a tool to help the attorney in explaining to the client so that they can make an informed decision about how best to proceed with their own case.
That's when I sat in that room after having that guy say to me, I didn't know it, and I drew those lines. I realized I was tremendous at explaining it, except I didn't have something graphic that would have an impact. And that made a difference. You asked, did it make a difference? I think from that moment on, it did. It allowed me a different tool to be able to explain all this stuff. And I'll be really, really over the top with this one. The law is the most important body of knowledge you can possibly learn. It encompasses everything. That door handle, why it's there. It's a building code. What else? Everything has some association with law, and I think people basically understand that. But it's pervasive and it's important. And so as we set examples of advocates of that, as far as I'm concerned, that's part of what our responsibility is to our fellow citizens. I don't know about you, but it used to be if I went to, let's say, an event and somebody came up to me and said, "Do you have a minute?" Why are they asking me that question? It's on the cheap, and you're going to get experience on an event that's important to them.
Right.
And
we call those gotta minutes, and we get a lot of them, especially if we're walking through like a municipal client city hall. Just by being there, a lot of times you get pulled into things and talked to about stuff that you would not necessarily have anticipated. But just to go back to and round out the point that you made a moment ago about how the law pervades everything, you're right. I mean, we're out there walking around and we're creating legal duties for ourselves that we don't even know about, right? You're walking down the street. Well, anytime you're doing anything that even involves another person, you've got a general duty to act reasonably, right? And this is the basis of the law of negligence, essentially. If I'm walking along and I run somebody over, was I behaving reasonably or not? And am I now, as a result of that, responsible for whatever injuries they may have incurred? Driving a car. Most of the traffic laws relate to how do you behave reasonably behind the wheel of a car, right? And what penalties and obligations are going to be associated with the privilege of driving. And you can take this into any other area, including contract law and what do you do with responsibilities that you may have under a contract. And people are out there creating contracts that they didn't even know about. So it does pervade all areas of life. And I'm sure there are other things that do too. But the law is unique, I think, in that you don't really become aware of it as the average person until something has become a problem, right? Or something has gotten screwed up. And now you're diving into, what does my homeowner's insurance policy say about whether this is covered, or what does my accident or collision policy suggest about what's covered here? And so for most people, they're not going to begin to dive into that until there's a problem. And that, I think, is some of the stress and anxiety that you referred to earlier about coming to the attorney's office in the first place.
Yeah. So. And we can make it palatable.
Right.
Depending on our empathy and whatever.
And Gilbert's paradigm is something that helps everybody do that. So, folks, I am going to, I've gotten permission from Jack to share the paradigm, so I'm going to float that across the screen, so y'all are going to see that. And I look forward to continuing this dialogue at some point, maybe having Jack back on to talk about a number of other things that could come up in municipal law or tax law, or who knows what else it could be. But folks, if you do want us to continue doing the podcast, please like, share, subscribe, do all those sorts of things. Tell your friends about us, and we'll keep cranking out episodes if you show us that you want us to. Jack, thanks so much for coming on. I appreciate it.
And I'll call the administration, see if I can bump that grade up.
Yeah. Sounds good, Jack. Thanks.
Thank you.